If you are facing criminal charges in New York City, your lawyer may be able to get your case dismissed. Cases are dismissed for a variety of reasons, such as when a person is provably innocent. Cases are also sometimes dismissed for technical reasons, even when a person is guilty. I'm going to go over the main ways you can get a criminal case dismissed in New York City, which includes exculpatory evidence, legal insufficiency, constitutional violations, and speedy trial violations. There's some other ways to get cases dismissed in New York City, but those are the main ones, so we'll discuss them. You may be able to get your case dismissed if you have exculpatory evidence that proves you didn't commit the crimes for which you were charged. For instance, let's say you're charged with domestic violence and the alleged victim says that you assaulted them at a specific street corner at a specific time. But you know that you were just in a heated argument that never became physical. If your criminal defense attorney were to subpoena video footage from nearby stores and obtain video footage that shows that you and the complainant were in an argument but it never became physical, then you would have exculpatory evidence showing that the incident as alleged by the complainant never occurred. Typically, in this situation, it would be the prosecution, not the judge, that after reviewing the video evidence would agree to dismiss the case. If the prosecution wouldn't agree to dismiss the case, you could ask the judge to dismiss the case in the interest of justice, although such dismissals by the court are surprisingly rare. The unfortunate truth is that if the prosecution is not willing to dismiss your case in this sort of scenario, your ultimate remedy will be to go to trial and show the jury the video that shows your innocence. That said, if the video clearly shows that you're innocent, most prosecutors will agree to dismiss the case because it won't be worth their time to further prosecute a case that they know that they will lose at trial. Because they have to prove a case beyond a reasonable doubt, and if you have evidence showing that you're innocent, they're not going to be able to prove their case beyond a reasonable doubt. On the other hand, if the exculpatory evidence does not clearly show your innocence, then the evidence may not be enough for the prosecution to agree to dismiss the case, although it could be enough to win at trial or to get the prosecution to offer a much better deal. For instance, using the same domestic violence example, let's say that the incident wasn't on video, so you don't have objective proof that you didn't commit the crime. However, let's say that the complainant later tells you and the prosecution that she was very drunk and she doesn't actually remember what happened. Although this statement of hers isn't enough to prove that you're innocent, the prosecution will likely realize that that statement may create reasonable doubt as to your guilt, and the prosecution could very likely lose at trial. So in that event, the prosecution may still choose to drop the charges or offer a much better deal due to their knowledge that they have a weak case because the main witness is saying, well, they don't actually remember what happened. A criminal case can be dismissed in New York City for legal insufficiency when your attorney files a motion to the court that argues that the allegations, even if true, don't amount to a crime. In a nutshell, this argument says, the prosecution's alleging that I did X, but so what? Even if I did that, that is not a crime, and therefore this case should be dismissed. For instance, let's say that you're charged with stalking in the 4th degree. The alleged victim says that every weekday you're on the same subway platform as them at the same time, and you follow them onto the train and you make eye contact. You then exit the train at the same stop as the complainant, and you follow that person into the same building each day, although you get off on a different floor. And in this scenario, you say, yeah, that's right. You apparently live in the same neighborhood as someone who works 9 to 5 in the same skyscraper as you. You're not stalking this person, you're going to work. It's incidental that you're following the same path as this person. So in this sort of scenario, your lawyer could file a motion to dismiss, claiming that the elements of stalking aren't established. For instance, stalking requires the element that the defendant engage in a course of conduct with no valid purpose. So in this hypothetical, you have a valid purpose, to go to work. A case can also get dismissed when there's a constitutional violation, such as when the police unlawfully search you. For instance, say that you're charged with criminal possession of a weapon after the police search your car and find a gun. If the police did not have legal justification to search your car, then the gun they recovered could be suppressed as evidence. When evidence gets suppressed, that means the government cannot use it against you at trial. So, when a gun gets suppressed from evidence because it's the result of an unlawful search, the government will not be able to tell the jury that a gun was recovered from you or your car or your home, etc., nor can it show the jury the gun. When the evidence is suppressed, prosecutors will typically agree to dismiss a case when they can't prove their case without that suppressed evidence. One of the most common ways that a criminal case gets dismissed in New York is through CPL 3030, which is the Speedy Trial statute in New York. If the prosecution is not ready for trial soon enough after your first appearance in court, then your case can be dismissed. The length of time by which the prosecution must be ready for trial depends on the seriousness of the charge. The prosecution has more time to be ready for more serious cases. Oftentimes, prosecutors are so overworked that they don't have the time to be ready for all of their cases. And because of that, sometimes they don't prioritize petty cases. And petty misdemeanors will sometimes be dismissed because the prosecution doesn't get ready for trial in sufficient time. If you've been charged with a crime in New York City, give me a call for a free consultation. I can assess your case to determine the best strategy and effort to get your case dismissed.